that an air balloon or something?
You say you're on now.
I'm actually on now. I'm going to say what I just said again. Thank you all for your patience. Thank you, and audience, for joining us this afternoon. And thank you to our guests, of whom I'm happy to have on this panel. We are here in Champaign, Urbana.
You have to have it.
Oh, okay. We are here in Champaign, Urbana. I'll try to do my mask so that you guys can still hear me. Thank you for joining our panel. Let's talk accountability and community control. My name is Carol Lamb, State Representative for the 103rd District, which is Champaign and Urbana. Today we're going to delve into two topics. You may have joined the first one that talked about reimagining police, really what the community wants in policing. This panel will build upon that conversation that took place at 2 o'clock and go further into what's preventing us from having the type of policing that we believe our community should have. Qualified unity, and collective bargaining agreements. How do they work for police? These mechanisms are complex and difficult to understand for many reasons. It took me a very long time. Thank you, Representative Tarver. We can't fight for meaningful change until we understand the systems that we're up against. This is why we brought together this incredible panel of experts, whom I'm honored to introduce and share with you all. Before I introduce the panel, I want to make sure that we all are at least working together and collectively understanding why this is so important. It is very difficult for us as a community to have policing that reflects its broader implications without accountability. Tarver of the 25th District of Illinois. He has a deep history of public service in both public and private sector. We work together frequently throughout the time together in the General Assembly, short but very impactful, particularly on legislation concerning criminal justice reform and police accountability. He's a lawyer, he's an advocate, he is absolutely a grassroots legislator, and I'm happy to have him join us today. He is the sponsor of the bill to look at qualified immunity and to reform it. Representative Tarver, thank you so much for joining us this afternoon. Also, in introducing our other panelists, you heard from Kadeen Bennett, the Director of Advocacy and Intergovernmental Affairs for the ACLU of Illinois in the first panel. She stayed with us because this conversation will require the help of the ACLU in order for us to make the changes at the state capitol necessary. As a recognized advocate at the state capitol, Kadeen is well versed in issues surrounding policing, criminal justice, and juvenile justice, the First Amendment, privacy, and many social justice initiatives of the state. We have worked together over the last 7 years in the State House as a state legislator, and I have come to really rely on Kadeen because I know she will tell me the truth, nothing but the truth, and make sure that we get the answers we need and pass the laws that are necessary. Thank you so much, Kadeen, for joining us for the second panel. With me also is Christopher Evans, who is a long-term activist, organizer, artist in the Urbana-Champaign community, as well as a newly elected Urbana City Council member in the 2021 municipal election. Ms. Evans also has experience working with me and my husband, the Champaign-Urbana Citizens for Peace and Justice, for over a decade, with whom we worked on issues surrounding videotaping of the police brutality, racial profiling, ineffective legal representation, and felony disenfranchisement, just to name a few of those campaigns. Mr. President, thank you so much for joining us this afternoon. And last but not least, the Workers Center for Racial Justice, Mrs. Joy, and both, help me pronounce your name, Joy, your last name.
Immobile.
The audio. She's on mute.
Oh, can you?
Immobile, can you hear me?
She just did the speaker.
Oh. Joy, can you hear me?
I can, there's an echo.
We're trying to take that out. Okay, Joy, please say your last name for us so that I don't mess it up.
No worries, it's Immobile.
Immobile, thank you.
Correct.
Joy serves as the political director. We still got a little echo. Okay? Yeah, you can turn it all the way down. Hold on a second. Is that better? Yes. Excellent. Joy is political director for the Workers Center for Racial Justice, a grassroots nonprofit Black liberation organization. Her work with WCRJ has prepared her well for the fight against unjust police union contracts. And for our discussion today, she's going to help us understand not only the reality of the collective bargaining contract for police, as well as the changes that are necessary. I will say at 4:30, we'll have a special guest join this wonderful panel. Ben and Jerry's will join us at 4:30. We will incorporate him right on into the conversation. He's the author of the book Above the Law, How About Immunity Protect the Police, with a foreword by Michael, PKA Mike, and the co-host of the podcast, Unaccountable, Among Musicians, Fellow Black, which recounts the shocking stories of police and discuss urgent need for police reform with actors, activists, scholars, athletes, musicians, poets, and politicians. He will join us at the 4:30. With that, it is my honor to start with the first very hard question for this panel. What in the world is qualified immunity? What is it? In layman's terms, also of what qualified immunity is.
And I could start, Curtis, if you want, whatever works for you. Yeah, so just to capture something that's really complicated and can you all hear me? Okay, can folks hear me now? Hopefully. So essentially to capture something that's super complicated in a very short period of time. So the doctrine, and as I talk about it, I'm going to talk about it specifically as it relates to law enforcement. So the doctrine of qualified immunity protects law enforcement officers from liability unless the official violated what's called a clearly established constitutional right, meaning a court already declared similar behavior in a previous case to be unconstitutional. So that's a high bar that effectively shields law enforcement from accountability, and it denies victims damages when they're due. So just a little bit of history. Back in 1871, in the wake of the Civil War, we had white vigilantes who roamed the South, violently attacking newly freed Black folks, and law enforcement officials were doing little to stop them and even taking part themselves. So Congress wanted to give people the ability to defend their own civil rights, and they believed that federal juries would be the most likely to enforce the Constitution rather than state folks. So Congress created the federal right to sue state and local government officials for violating the Constitution under what's known as Section 1983. But the Supreme Court initially interpreted Section 1983 super narrowly, so it wasn't really used that much, and not very many cases were successful. Fast forward to the 50s, during the Civil Rights Movement, more lawyers started to use it, especially after the Supreme Court in this 1961 decision reaffirmed that folks can sue law enforcement officials under Section 1983 for civil rights violations. Fast forward to the 1967, the Supreme Court then recognized qualified immunity as a defense to 1983 claims. They ruled that police officers and other government officials have qualified immunity from those 1983 lawsuits as long as they were acting in good faith to enforce law as they understood it at the time, even if that law was later found to be unconstitutional. Skipping ahead to 1982, the Supreme Court offered a reinterpretation of qualified immunity that's essentially our current test for the doctrine. So they say that qualified immunity is generally available if the law a government official violated isn't clearly established. They didn't say what counts as a clearly established right. And in later rulings over the last 40 years, the Supreme Court has made that standard even more and more difficult to meet. So where does that leave us now? So qualified immunity makes it nearly impossible for individuals to sue police officers by requiring proof that they violated that clearly established law. So that would require plaintiffs to prove that either the Court of Appeals in their jurisdiction or a consensus of cases around several appeals courts or the Supreme Court has already found a prior nearly identical incident to be unconstitutional in order for that officer to be liable. So there's a researcher with the Cato Institute who I think sums it up best. He says, it's quite common for the courts to say in applying qualified immunity, yes, your rights were violated, but we can't find a prior case where somebody else's rights were violated with sufficiently similar facts as your case. Therefore, the defendant gets qualified immunity and the case is dismissed. So some examples of how that plays out, where it's an extremely high bar for what counts as similar, and that it results in an overprotection for law enforcement. So one case is Baxter versus Bracey. So a Nashville police officer released a police dog on Mr. Baxter, who had surrendered and was sitting with his hands in the air. Mr. Baxter was beaten and sued the officer. Though the court in a same circuit had ruled a prior incident was unconstitutional, in that case, an officer released a dog on someone who had surrendered while lying down as opposed to sitting with his hands in the air. That Sixth Circuit ruled that the factual distinctions were enough for the officer to retain his qualified immunity. Qualified immunity, I guess one more example would be this Jessup case. So 3 police officers in Fresno, California, allegedly stole over $200,000 from 2 businessmen they searched. The men sued the officers for unreasonable search and seizure under the Constitution, but the Ninth Circuit ruled that the officers could not be held liable because there was no clearly established law saying that officers cannot steal property seized pursuant to a warrant, even though it conceded that virtually every human society teaches theft generally is morally wrong. And since there were no prior similar incidents, the officers were protected. So the end result is a severe undermining of police accountability in this country because a statute that was originally meant to be a way of holding state and local officials accountable has been interpreted in a way where it is almost impossible to have any kind of recourse under that law.
First of all, the important fact that you said is similarly situated incident to match the other in order for it to be considered liable. Representative Tarver, you have taken this on to really not only educate me, I had no understanding of how qualified immunity differs for elected officials like us and qualified immunity for policing. What's the difference and why are you having a discussion in a way that seems to make other disorderly get rid of that?
I'm sorry, Carol, you're breaking up just a tad bit. I didn't hear the last part of the question.
Just trying to make a distinction because as Nadine just laid out, we gave the examples that each of the incidents that she named in a policing incident could not happen or apply to us as elected officials. What's the difference between an elected official's qualified immunity versus what she's describing in these accountability cases?
I mean, I tend to think more of it, what you're talking about in terms of like tort immunity. And I think the general purpose of it is, and I'll use a kind of example to make sense in Illinois. You know, if we decide to put funds one place and not into roads, and then someone hits a pothole and, you know, and damages their car and hurts themselves, I mean, it's kind of difficult to come back and say, hey, you as legislators should have placed this money, you know, in a different bucket, right? You should have, you know, repaved roads as opposed to spending it on something different. That's wholly different than, you know, a situation like or in Chicago where police officers, you know, knows a woman has a 1-year-old in the back seat. They exchange words. He gets back in his car, reverses it, and then rams it into the back of her, knowing there's a 1-year-old in the car. Those are just drastically different situations. And I don't know that I've heard of a situation in which an elected official, violated someone's civil rights in a way that, Kadeen has outlined as it relates to law enforcement.
How can we, if we've seen the massive nationwide protests around the country since the killing of George Floyd and even international, it's over. What is preventing us from getting to the heart of changing qualified immunity so that police can be held accountable? What do we need to do in order to do that?
And I think anyone can jump in on this. I would say just generally, I think the public needs to be educated in a way to understand that, qualified immunity and what it does, it doesn't help. It doesn't help general society, right? It incentivizes police officers or law enforcement in general to commit some of the most egregious acts and just be more creative than the last officer was in violating someone's civil rights. So that public education piece, I think, is important. Informing people this is not something that's anti-police, but more or less, I think, allowing people when their rights have been violated to at least have access to the civil justice system in a way that they don't have right now. And I think Kadeen and Drake could probably jump in as well.
Yeah, I think the other issue is
what is it we need to do? Maybe that brings us into our CBA, because how does CBA connect to the collective bargaining agreements, connect to qualified immunity? Or is it? Feel free to jump in there.
I'm sorry, Rep. Edmonds. It's hard to hear you. Can you repeat that again, please?
Yes. What Tara just shared with us is that there is a difference in qualified immunity, but what is keeping us from being able to not only reform the qualified immunity system, right, but to deal with collective bargaining that it have impact on qualified immunity?
I'll tackle that. So obstruction to police accountability is so deeply embedded into state law and also within collective bargaining agreements. I'll talk on briefly on collective bargaining agreements and what it is. It's often misunderstood for qualified immunity, but it's its own separate piece of a legal contract that also obstructs police accountability. In collective bargaining agreement, it's a written legal contract between an employer and a union representing the employees. And so in reference of our panel today around police accountability, a collective bargaining agreement with the police would be between police unions and local cities. And the purpose of collective bargaining agreements is for employees to negotiate working conditions with their employees around pay, benefits, hours, leave, safety policies, and things of that nature. But now what we're seeing is that police unions are exploiting collective bargaining powers outside of the scope of legitimate labor rights and working conditions. And this is how now we're seeing collective bargaining agreements show up in our communities. It's not, a secret that U.S. police abuse citizens and kill civilians at much higher rates than any other country. And there's no question that the number of police killings of civilians are disproportionately Black and brown. And so for decades, we have consecutively heard and seen Black bodies being killed by police. And we all know the high profile cases: Eric Gardner, Laquan McDonald, Sandra Bland, Michael Brown, Breonna Taylor, and hundreds of thousands of others who have not come to the forefront and who have lost their lives at the hands of police. And often at times our communities are asking for justice. We're seeking justice, even when caught on video. And we often ask the question, why? Why doesn't our judiciary system hold police accountable to citizen and civilian abuse? And so collective bargaining agreements, as well as qualified immunity, has been a tool that has historically shielded police officers from accountability and obstruct justice that Black and brown communities are demanding. And so in collective bargaining agreements, we have to protect our democracy. Elected officials and not special interest police unions should have the final say on critical policy and safety reforms in Illinois. That should be done through the state and not through these collective bargaining agreements.
And just to add, I think part of the issue is that the political will to end it. I think what we've seen in different parts of the country as folks have been trying to end qualified immunity at the local level is that there's a lot of misinformation from law enforcement. It's intentional misinformation. Things like it's anti-union to support ending blanket immunity. It's
How do we describe what policy is to a citizen?
Rep. Emmons, can you hear me? Can you hear me at all, Rep. Emmons? Oh, I was just responding back to the point in terms of the why it's not possible or it's hard to do it. I was just saying that there is an issue around the political will to end qualified immunity, that what we're seeing in other parts of the country is that for law enforcement, this is kind of their big hill to die on, and they're using intentional misinformation with things like it's anti-union to support ending this blanket immunity. That's not the case. I mean, especially as to Rep. Tarver's point about why this kind of immunity is different from other kinds of immunity that folks may have, elected officials may have. And this idea that it's an extreme reform, that if we were to do this, then law enforcement would be unable to do their job. What we're asking for is a moderate change. We're essentially asking folks to be able, when their rights have been violated, and their constitutional rights, so that's a pretty high standard, when those have been violated by law enforcement, they deserve to be able to go to a court and to have a judge determine whether those constitutional rights are violated or not whether or not this blanket immunity applies. And for many people, they never get that opportunity because of how the law has been perverted over time.
Rep. Ammons, we can't hear you.
Are you muted, Rep. Emmons? Rep. Emmons, I don't know if you can hear me, but we can't hear you. I'm looking at Kadeen and Joy as well.
It's working. Sweet.
I believe they're working on it. I just texted them to let them know.
Okay, can you all hear me now?
We sure can.
Okay, great. So we have a feedback issue inside the building and it keeps interrupting the internet. Let me just go back. We want to make sure that people understand that there's a specific distinction between qualified immunity and collective bargaining agreements. Is that, do I have that right?
Yes.
Yes, great. Qualified immunity is something that happens on the back end. And Kadeen, you just mentioned that it's a high threshold, it's a high level in order for a person to be able to take a case to the courts. and deal with this officer under this issue of qualified immunity. Can you further explain and make that kind of crystal clear how people interact, and they don't realize that this is what's preventing them from getting justice in so many cases? They don't understand that this is the qualified immunity.
Yeah, I think in most situations, people file a lawsuit and they expect to go before a judge, and the judge would determine whether or not they're right or the defendant is right. In the case of in dealing with whatever issue happened, in the case of qualified immunity, it ends up being this litigation around whether or not a blanket immunity applies. There is no first conversation about whether or not somebody's rights have been violated. It kind of goes against what we would expect. And so that means that people end up filing, go to court, and they end up not ever getting resolution about the harm that they've experienced. And then there's never a declaration that this officer has done something that violates someone's constitutional rights, all because of that whole clearly established law, which is just super narrow in terms of what circumstances can apply. The examples I gave you before are pretty egregious things that we can all agree are things that should be found to be unconstitutional. That ability, folks don't have it. It also prevents people from even trying to go to court, because if somebody's a lawyer and this clearly established law for qualified immunity is in place, you're less likely to want to take that case because the likelihood of winning is really limited. That's why Rep. Tarver's bill is so critical for folks in Illinois.
Rep. Tarver, can you talk about the bill that Kadeen just referenced for Illinois and what you're trying to do with that bill?
Sure. I mean, I think it's a relatively straightforward bill in that what we're looking to do is allow individuals to have standing in court against law enforcement that violate their constitutional rights. It just gives them the opportunity to get past this insurmountable shield, which I'll just say, to my mind, the legislature at whatever level is who makes laws. The courts are supposed to interpret the laws. This is really judicially created, and I think that's the other issue. Is that the court is taking it upon itself to essentially make this law and interpret it in a way that is just insurmountable for people. And again, we're talking about particularly folks who have the least amount of means. So to Kadeen's point, we're talking about, and Joy's point, we're talking about Black and brown people primarily, right? We're talking about individuals who really don't have access to the judicial system in a way that some others do as well. And we're talking about attorneys who take these cases on a contingency basis, which already means that they have to put up all the cost for each case to get it through trial. So even from the notion of, and I've heard police officers say, hey, this is going to bring frivolous lawsuits. Nobody's going to spend $50, $60, $70, $100,000 getting a case to trial, typically for frivolous matters. I think you might be muted, Rep. Emmons.
I'm on mute, aren't I? I'm sorry,
Yes.
I was on mute. The mask, the mute, all this is driving me crazy. Okay, sorry about that. I'm about to lose it, y'all. But we worked in January with our criminal justice reform package, and there was an omnibus package that had lots of pieces in it. One of the things that we were trying to do at that time was to include this provision with ultimately was the Achilles heel, right, of the police unions and the police advocacy groups that were opposed to all of the legislation, not just qualified immunity, but all of your legislation. But they were willing, and this is a point I want to raise, they were willing, meaning those who were opposed to our criminal justice reform package, they were willing to give us, quote unquote, give us everything else but this issue of qualified immunity. Can you talk about how that negotiation was happening? And ultimately, I know how we had to take it out of the bill to get the other pieces done. Can you share your perspective on that?
Yeah, I'll share my perspective because I did not negotiate the bill.
Yeah.
But what I'll say is this. I'm not terribly surprised that law enforcement and others, wanted qualified immunity taken out of the bill. But I think it's important to note that at the same time they pledged to take that out of the bill, to remain neutral or whatever it was, in order for this bill to pass. They then got, a gift wrapped treat in a trailer bill, which clawed back some of the things that were in the original bill. So I think, the unfortunate thing is to the extent that they negotiated it, in my mind, they negotiated in bad faith, because the original bill passes, you then essentially gut that and don't include in qualified immunity. And then you say, well, let's have a task force. If you look at the task force right now, only the Speaker of the House has actually appointed every member to the task force at this point. I don't think the Senate President has. Governor Pritzker has 8 appointees. I believe he's only appointed 2. You know, that group was supposed to meet and issue a report by May 1st. Then in the trailer bill, it was one of the 7 or 8 extensions in the bill that really kind of flew under the radar. And then the report is now due, you know, October 31st. And I don't see how that date is going to be made as well. So I think for all of the talk about negotiations in good faith, I think it wasn't good faith, and it leaves us in a bad position right now, because we still don't have a report that seems like it's going to be, you know, issued at the end of the next month, and we're left to try to figure out, you know, where qualified immunity stands at this point.
Thank you for clearing that up. I want to turn to my colleague, Christopher Evans, and I may have to share my screen with him just so that we don't mess up the audio, okay? But he's an alderman in the city of Urbana, a long-term activist with me, organizer, and now he's an alderman who has to sit there and figure out something as important as the collective bargaining agreement for the city of Urbana. I'd like him to share his experience. He's a first-time alderman, and then I want your reaction to what his experience was after he shares it. So I'm gonna give it to Chris Evans.
Thank you. Yeah, just real quick, and I bet this won't surprise you how this plays out in small cities like Urbana, but we had a general election April 6th. 5 new councilmen were elected. May 3rd, we were sworn in, and then May 17th, we went to closed session to talk about the new FOP contract that we had to approve. The FOP contract had expired the year before, and because of the pandemic, there was no resolution about the contract. So 5 new council members are introduced to the collective bargaining system. We are told by we had a labor attorney who led the negotiations for the city of Urbana. By the way, we were never told who was all on the negotiating team for the city of Urbana. We were not given their contact information, and we were not given a copy of the last contract that we were replacing. So we were very ignorant, but we were told that the FOP is a very difficult union to bargain with, that it was attempted to, last time, to have officers fired if they used excessive force. Officers could be fired if they falsified police reports. The FOP last time said no. And then we were also told that the grievance arbitration system, in which officers can challenge rulings made by their command staff or the city against them, the officers can use a binding arbitration system that usually keeps them employed. So that was May 17th. We have a 2-hour meeting about the upcoming FOP contract. Councilmen like myself think, okay, I'm going to write what I want changed from the old. I went and looked for the old contract, found it, and so I decided what I wanted to replace. And I wanted to add 8 reasons why an officer could be fired involving excessive force and dishonesty with criminal cases. What was unusual about the Urbana city contract with the FOP is that the FOP was allowed to control how the civilian, we have an established civilian police review board, not a control board, but a review board. And the FOP was controlling how they were allowed to do their investigations. So there were a lot of stipulations within the FOP contract that the civilian review board could not subpoena documents. They could not compel officers to testify. No third-party investigations could be done. And there were several other things that the civilian review board was, or it had to be private, that the officers' names could not be made public. So they had all these things put in. Also, they could, people could be prosecuted if they filed a false complaint. And also, there was one more.
That's
They
against the law.
wanted, anyway, so okay, so that was what we wanted to change in the FOP contract. So unbeknownst to us, the negotiators decide on what the new contract will be in June of 2021. And then, to our surprise, we found out later that the rank and file of the police union were allowed to approve the contract August 12th. And then all of a sudden, September 3rd, we are given the first look at the new contract and told to approve it on September 7th. So that's the story.
Okay, wait a minute. So you're an alderman in a city in the United States
Right.
that could not see the police contract, could not make any suggested changes to it at all. And I think you shared with me that the attorney that is supposed to represent the city, the attorney shared with you the reason why you couldn't make any actual changes to the collective bargaining agreement. Can you share what you remember on that?
Yes, so to our surprise, so naturally we said, well, we want to make these changes to the contract that you've just now shown us. He said, you cannot, and here's why. There is a law there's the Illinois Labor Relations Act passed in 1986, provides that well, number one, it provides that individual officers are allowed binding arbitration, but also the entire union is allowed what it's called an interest arbitrator when they have an impasse with an entire municipality. And the labor attorney told us that if you go with an interest arbitrator who's brought in from the outside, their word is final, their decisions are final, and both parties have to agree to accept it, that they always rule with the union, they always rule against the cities.
So now, Joy, right? We need certainly you, Representative Tarver and I have to grapple with these issues in the legislature, but what you just heard from an alderman in the United States, in the state of Illinois, who in essence said he had no input in reality for the collective bargaining agreement that ultimately he as a council member has to vote for, of which he voted no, thank goodness. How do we deal with this, Joy?
Yeah. So first, I think the timeline is just absurd. But my main point that I would like to talk about is the purpose of collective bargaining rights. And the essential purpose is around bargaining around working conditions and labor rights. I don't think that collective bargaining rights should be places where we negotiate police reform. That should be done in theory with elected officials who represent the people in their interests, who determine those police reforms. So police unions who have their own special agenda should not be at the table negotiating around these police reforms. And ideally, we wouldn't want police unions to be at these tables negotiating these reforms. And police union contracts should solely just be about workplace conditions and labor rights. And so that's my biggest concern that I think is misconstrued when we have these negotiations with police unions.
Thing that we did, of course, we understand what collective bargaining is. My husband was the president of the union here in our community for a long time, and we are negotiating over healthcare. We're negotiating over places where you're going to actually physically work in that place, or uniforms, whether you have it or not, right? How many days in vacation and things of that nature. But what makes these CBAs stand above all other unions? Service unions don't have these privileges.
Exactly. And that is my main point. It shouldn't be. It shouldn't be. And there's also in the Illinois Public Relations Act, which the councilman referred to as well, it mentions this act takes precedence clause as well, where anything in collective bargaining agreement takes precedent over state law. So that's something else in the legislature that we'll have to revisit to address.
Representative Tarver, I read that law, actually. I just read it a couple of days ago as we was working on this issue of reforming collective bargaining agreements in the state for police contracts. And in that specific part of the code, it literally says, and I'm literally working on this bill, so you understand that. I'm looking at every line of the language. At the top, okay, I'm gonna change these things, but at the bottom it says what Joy just said, that it supersedes. So even if we do pass whatever we pass, how do we fix that portion of it so that these kind of bargaining agreements don't supersede state law? Because otherwise it won't even make a difference if we put the reforms in.
I mean, I think it's a good question. I mean, I know I'm saying Kadeem may be better to answer this, but at this point, you know, it seems like our hands are somewhat tied. I mean, I can't see a court interpreting that any different than, you know, the language is pretty clear. You know, I don't know if we as a body have the political will to do anything about it, unfortunately.
Yeah, I think that's the frustrating part. And Kadeem, you can jump in on that, because for us, Tarver and I, certainly, we see that there's no way for us to take a civil right of action as a citizen with the QI there, as these CBAs that supersede state law. How can we?
So, and you cut out a little bit at the end, but I think I got the gist of what you were saying. I do think, like, there are some attempts. So, for example, the sworn affidavit requirement, I think there's language there that says that if it's subject to the next contract, the remainder of the contract, if that language is in there, it doesn't change anything. But with the next contract, it have an impact. But I do think, for Rep. Tarver's point, it's a political will question where the General Assembly has to decide that meaningful police reform is a priority and willing to make changes that are narrow. And I think this is where law enforcement, what they're telling other unions is, you know, they're coming for us, they'll come for you next. But the police folks in Illinois have the most protection of any other entity, and they have the ability to do the most harm in, like, everyday scenarios. I know in Washington, D.C., their city council passed legislation removing all disciplinary matters from the scope of police union contracts. That's something they did. Their underlying law might be different. But what ends up happening is that all the things that we do, we have to figure out if it's actually going to be enforceable or doable. And it gets to exactly what law enforcement wants. They want to be able to limit their ability to be held accountable. I do think, in terms of the education, I think it's education of legislators, because at the end of the day, they're the ultimate decision makers. I did see that there was a constitutional amendment proposed that deals with collective bargaining, where I think it's worth exploring more if that were to become a change to our constitution, whether or not it would make it almost impossible for us to do anything as it relates to police disciplinary or police accountability. And I think there are ways to craft narrow pieces of legislation that doesn't disturb the intent of collective bargaining agreements in the most positive ways that they're meant to be, while still dealing with this accountability issue. But again, you'll need enough legislators to say yes when that time comes to run this bill.
And I think that you just hit on something really important around, how we engage and educate. Right? How do we engage and educate people on a topic that they, in many cases, just don't understand how it applies? It took Representative Tarver about 10 minutes to describe the scenario as to, in order for me as a victim to get justice, every one of these things has to line up, right? Those things have to be equal or nearly the same in order for me or my family member or whoever to get justice in these cases. how do we inform the community to organize around this issue? Because as you know, legislators are hard to convince to do things if the public is saying, oh, well, we'll just see you at the next protest.
Yeah. Rep. Ammons, if I could step in really quickly, back to the last point around this act takes precedence clause. In January, the Illinois General Assembly passed a big police accountability package with the passage of the Safety Act, and along other reforms that outlawed the routine destruction of police disciplinary records, and ends the signed affidavit requirements of complaints against police officers. And however, again, with this act takes precedence clause, it really undermines the legal authority of that Safety Act with respect to those provisions. And so in terms of what we can do in the Illinois General Assembly, we have to narrowly amend that section within the Illinois Police Labor Relations Act to exempt police unions from that act takes precedence clause, in order for any police accountability measures that we push through to actually be sustainable and hold weight. It's also in relation to Khadi, what you mentioned about the Constitution Amendment. Now we're on a countdown that could place a barrier on future police accountability for the viewable seizure if this does get passed. And so I know the Worker Center, we are actively working around outlawing police contract abuse through these collective bargaining agreements before this amendment gets passed, so that there is a pathway to hold police officers accountable.
Representative Tarver, I know you've worked on these police cases in the past as a lawyer. Joy just mentioned the constitutional amendment that protects workers in broad terms, and a concern that if that amendment passes, then it could prevent accountability of the police, because they would in essence fall under these kind of protections. Are you familiar with that? Or are you concerned at all about that hindering?
I mean, I guess generally there's always concern. That wasn't my read on it, but again, I think to Joy and Kadeen's point, we don't want to find out the hard way when it's interpreted by a court, because we've kind of seen how that can go. So, in full disclosure, I started off my career on civil rights defense cases. That's why I left my first firm. And then I switched and started doing plaintiff's work. So I've seen this from both sides. And again, that wasn't my read on the constitutional amendment, but yeah, I have concerns anytime that we might potentially be shielding law enforcement even more than they already shielded. And I just want to say this very quickly about political will, because I think it's important. You can look this up. Boone County Sheriff's Deputy Robert Rosencrantz, when he came on the Boone County Sheriff's Force, within 1 year, they went from 12 police chases to 24. He initiated 6 or 7. One ended up being fatal, African-American woman. And ironically, this GA, Representative Sosnowski introduced the bill because Robert Rosencrantz's dog got hit and killed in a DUI case. And the General Assembly, on a bipartisan basis, passed the bill, and at least the House did, to increase the penalties if you have a DUI and kill a police dog. So when we talk about political will, that's what we're dealing with. We can come together, and I didn't, by the way, obviously, but we can come together to shield a police dog and make sure that someone who has allegedly a DUI has a heightened penalty. But when people are being shot and killed and abused, and there's a lack of trust from both police, law enforcement to the community, and vice versa, we can't seem to do anything about that. So I just want to make sure we level set when we talk about political will here in Illinois.
And just to add to that, I think to your point, Rep. Ammons, about what we're doing to get the word out, I think Rep. Tarver and I have spent time talking to, I think we've reached out to almost every member, I think every member in the House, to see if they're interested in having town halls or any kind of informational exchange with constituents. We've also talked about talking to their law enforcement folks so they understand what it is we're trying to accomplish with this bill, so there's no misinformation. Part of the issue that we see is that the police associations have their idea of what it is we're trying to accomplish, and what we are is just some it's super basic. It's potentially transformative if we have it, but it's a basic thing that we're asking for. The other thing is we're dealing with an environment. I know that folks during the summer and fall were protesting, talking about what are the things that we can do. And this is one of the things we said that you can do. I mean, we were pretty from the summer, fall, going into lame duck session. This was always on the table as one of those things. But now that we're here, what we're hearing is, well, you just did the Safety Act. Law enforcement, they're feeling like they're under attack. Law enforcement feels like they're being targeted. And the reality is, part of why we call the bill the Bad Apples Bill, even though it feels like more like an orchard, is that we can all agree that if you think there are bad apples out there, that those people should be held accountable. And even so, the pushback is really intense, even considering once, let's say, qualified immunity does not apply, so we get our bill, becomes law, there's still so many protections that exist in our legal system for law enforcement. There's the reasonable officer standard. There are all of these protections, more so than for you and I if we were in front of a civil court. So that reality wouldn't change at all with this bill becoming law.
Exactly. Likewise, too, the Workers Center for Racial Justice, we're working on language around outlawing police contract abuse. And so we lead weekly days of action where we ask community and constituents to send pre-written texts to Illinois General Assembly members and urging them to support this legislation, and also just doing the education piece around this in the community. This is definitely an issue that touches dear to people in Black and Brown communities who it disproportionately impacts. And so just educating them on what collective bargaining is and mobilizing them around this issue to actually get these laws passed.
Yes, I'm talking to the audience here, not you guys. I want to bring back Alderman Evans and just ask him, after his experience going through the collective bargaining experience as a city council member for the first time, are there provisions and ordinances that you all as members of the council are writing to then put framework around what the negotiator takes in the next collective bargaining, right?
Well, with regards to our Civilian Police Review Board, we want to change the ordinance dramatically so that the Civilian Review Board can subpoena documents and compel testimony from officers, and also allow for third-party investigations. Unfortunately, the contract that we were forced to, or did approve, in the contract, it is written in the FOP contract that the ordinance governing the Civilian Police Review Board must comply with the contract instead of the other way around. So we can't make any changes according to the contract. So, one of the things that the labor attorney said that would be, for the state to change in the Labor Relations Act, he said that Section 14H is where that interest arbitrator language is that allows for the unions to stay in control. The only thing we can do at the local level, and we get a second bite at the apple of 2023, when this current contract runs out again, is to not accept the contract and take our chances with interest arbitration.
Can I ask a question to the older person? I guess just in terms of, as we're talking about political will, when you get to the point where the contract is going to be renegotiated, do you think this experience has allowed your fellow older folks to rethink what you're willing to push back on for the next contract? And do you think there's enough support where if people are deciding, oh, there's a pressure to get this contract signed, but this big part of it could potentially still be at play, do you have a sense of where your folks would be?
Well, I will say that we have 4 of 7 council members that could do what you're saying. So.
Thank you.
This is a tricky space. So now I'm really circled up. Now, you guys, I mean, I'm completely circled up here. So the collective bargaining agreement says you got to do whatever is in the collective bargaining agreement, either by state or local law, which means that we have no choice, Joy. But if we're going to have any effect on the police collective bargaining agreements for the municipalities, we're going to have to change them. However, when we were working to do exactly that with Tarver's bill in the omnibus package, as you all may be aware, we had municipalities that were opposed to the issues that we were presenting on changing for collective bargaining, which was my bill, and qualified immunity, which was Representative Tarver's bill. So how do we get this done if we're just circling? It seems to me that we're circling the wagons around 2 issues that, in essence, both shield the police from accountability.
I think we are all in agreement that that this is really a hard fight that we're going to have to apply as much pressure on if we want to see some reforms passed. As stated in the earlier panel, we're fighting against a system that is working to protect a culture that promotes anti-Blackness, that protects police officers. And so we're going to have to continue to apply pressure and also apply pressure at the root of a lot of these laws that we're seeing.
Kadeen, what do you think we can do in this process?
I guess not to be, I'm trying not to be the road of being down about it. The reality is there are other states where this has happened. New Mexico, they've gotten rid of qualified immunity there. In Colorado, it's happened there. And the reason they were able to do it is that the folks who have the ability to vote for this voted for it. They were able to build coalitions that included union folks who understood why it's really important. And I think a way that this could move is to engage union folks who represent folks of color and Black folks, because this is an issue that's really important to their constituents. So I think that's where maybe it's a charge to our fellow union folks to see if they're willing to be leaders and supporters in this area as well. And I also think business folks, I think I saw, as many of you did, a lot of people reach out during the summer, like, we want to do something. We care about these issues. I think a way to care about these issues is put your company logo on, not even on the line, but just to say we, not just like Black Lives Matter, but Black Lives Matter, and we will do something that is helpful to your community so you are no longer abused by police officers. The other thing, and I've thought about this for a number of years, as in terms of the collective bargaining world, there's the Law Enforcement Officers Bill of Rights in Illinois, where as somebody who does criminal justice reform work, when I first saw it, I was like, wow, if the average person had these rights when they were arrested, this would be amazing. So they get to not be interrogated late at night, they get to have food, they get to see a lawyer, they have all of these rights. And I was asking a police lobbyist about it. I was like, where would you guys be if we were to introduce this for the average citizen? And they weren't jumping up and down to get it done. But I do think maybe tools like, if you think it's important for law enforcement, it should be important for the average person in a criminal context where, due process is at stake. So it doesn't get to the essence of what we're talking about, but it's a way to show that glaring difference in terms of how law enforcement officers are treated and people who are innocent until proven guilty are treated.
That's an excellent way to look at that. Representative Tarver, I think you was going to say, I saw you shake your head. Like, are we circling wagons, or Kadeen just gave us the suggestion here?
No, I think those are all very solid suggestions. I was shaking my head because it's 2021. We're still asking the same question. So that was it. And that's not, a dig at you. It's just literally, I'm trying to take in the fact that it's 2021 and we're asking those same questions. That's all.
I mean, I think that's the point, that what you just said crystallizes this point, because we've been circling the wagons, certainly for the last 20 years of my young experience, watching police cases go unaccountable for, not just in our community, but across the country. So we've been watching this for a long time, and we've been organizing around whether it's police deaths in our county jail, deaths of homeless people in our community. I mean, we've seen it happen. It's not just that it's Baltimore or Chicago, like people like to assume. It is literally all over the country, yet we don't have the political will.
Yeah.
Yet we don't, right? We have a lot of reasons why we don't have the political will, even though since George Floyd, we've lost a lot of brothers and sisters in the community at the hands of law enforcement, unarmed, right? So I don't know how we stop asking this question in reality. I want to stop asking this question, Tarver.
Well, I'll say this. One of the things that I think is most unfortunate is that people beat their chest about being the most equitable this in the nation, right? Whether it's clean energies purportedly, whether it's cannabis purportedly, right? We're the most equitable, most fair X, Y, and Z. And then you get to an issue like this, and then everybody, not everybody, but many people run for cover. I mean, why not have the most equitable, criminal justice reform laws in the nation if we really care, right? We beat our chest when we finally, get to 20% on BP numbers somewhere, right? Why is that? If we really want to have the boast to be the best, whatever it is in the nation, and we have the ability to do it, particularly with the current construction in both the House, the Senate, and the governor's office, I think that we should take advantage of that, because I don't think we'll have an opportunity to do so anytime soon if we don't take advantage of it right now.
Well, that's a good way to say that, because when we began to work on the criminal justice reform package, and you and I and all of us know it's not the most progressive thing we ever could have done. By no means, it's not the most progressive thing we ever could have done. Yet many of us received death threats. They put up a complete website with my picture on it and your picture on it, and several of our other members' pictures on it, telling these people that here's the enemies, right? Here are the people that you should call them, go after them. This is what we experience as elected officials trying to take on these very hard topics. And many people don't quite understand why we can't get it done, right? What you just described, we have a House, we have a Senate, we have the governor, many super majorities in both, and the governor's seat. And when we have all of those pieces in place, we still cannot get things like criminal justice reform done. We do march together very well when somebody else gets killed, right? Or there's another uprising. But what do we do preventatively to fix this stuff and get enough people educated, right? Because that's the reality. Unless they storm on the Capitol, not Michigan Avenue, that don't work. The people in Chicago need to stop shutting down Michigan Avenue and come to Springfield, because that's where the actual work gets done. How do we get organizers and activists involved in this process so we can get it done?
Yeah, I think you nailed it right on the head, Rep. Ammons, mobilizing communities, getting them educated, and bringing them out to Springfield. I would just encourage constituents to look for local organizations like the Worker Centers and others who are committed to these issues and get involved so that they can mobilize around these issues. I really like, Kadeen, you highlighted other cities who actually passed legislation prohibiting measures and collective bargaining agreements. I think hearing that is encouraging to know that we too can get this done in Illinois. And a lot of those legislation that we've seen that passed in other states, Orland, Connecticut, and Washington, D.C., those laws also withstood police union challenges in federal court. So it's doable, and so I like that there's an end of the tunnel, a light that we can get to. And so we do need mobilizing communities, educating them, and also doing a lot of lobbying in the Illinois General Assembly as well to get this passed.
Rep. Ammons, you're muted.
Unmute, Carol. How do we get communities involved? I'm asking Kadeen and Tarver and Alderman Evans to chime in on that. How do we get them involved? Because we will not be able to get the political will without the people. There's just no question.
I think it's also building relationships. So I saw that Every Town, which is an organization that does gun work, they had a petition in support of Rep. Tarver's bill. So I think like building the network. So it's, I mean, I think for some legislators, hearing from communities of color who are impacted is helpful. For some legislators, that is not helpful to them. There may be other organizations that maybe are the ones that they listen to. So I think it's identifying who those organizations are and also educating them to get them mobilized to take action could be helpful. You might be muted.
I think you're muted.
Okay, can you hear me now? Okay. I would just say that I'm encouraged. Ever got out there, and just locally, I've joined an Ubuntu group to help work on these issues, but teaming up with the organizations in your community that are doing this work, and get together and get out there.
Rep. Tarver?
We've been going door to door, quite honestly, and just trying to, be as grassroots as possible. And that way, we can have conversations with individuals one-on-one. Sometimes people don't want to necessarily express their opinions publicly, but it's been helpful to just get, opinions at the door. I mean, that's in addition to everything that Kadeen has said, and I think that Joy has said and will say as well. But being at the door has been particularly helpful for us.
If I could add one more thing too, I think it's important to really humanize these policies as well and really talk about with constituents, what impact will this have in my life and in my community? When we talk about Black and Brown communities who have been impacted by police abuse, police deaths in their family at the hands of police, and when we talk about the root cause of how we can fix this, that is how we mobilize community members to advocate around this and get involved.
Well, with that, I want to thank you all and open it up to the floor that's here in the library. I'll try my best to share their questions with you all for the next maybe about 15 minutes or so, so that we can close on time. But I wanted to open it up to those who are here or anyone who is watching this via Facebook who have questions. We can pose them to the panel at this point. We have a question here in the library. Go ahead.
Joy brought up the humanizing of the abuse. I think, okay, so does the Fraternal Order of Police also cover all the guards in the state prisons, all the guards at the federal prisons? Is it a different, are they protected the same though? So like if a guard rapes an inmate, can they be charged with that, or are they protected? So if we can come up with things that happen on a daily basis that cannot be that we cannot charge an officer or someone, an employee of ours, for doing that crime against somebody, if we can bring this out and even transporting someone from the county jail to another county jail, the fact that people cannot use the restroom and that they have to pee and poop in their pants, then that they're held in
It looks like they are.
Yeah, we lost them.
Joy, do you all have folks throughout the state?
Okay, I'm sorry. I got kicked off again here in the library. Can you all hear me well?
Yes.
Yeah.
I can summarize the question, and I don't know the answer to it. So I'm going to ask Tarver or Kadeen if you all know.
Sure.
can a person, an officer who is in correctional officer, are they also covered by qualified immunity? If they harm, violate, abuse an inmate, would it still cover them the same way that police qualified immunity covers them?
So I'll just say something very quickly. I think the original example she gave was if they rape someone. And I just want to be clear about qualified immunity is a civil standard. And so I don't want to sit here and suggest that if a correctional officer, someone, committed a crime or raped someone, that there's no access to justice, although that's a conversation we had as well. That depends on the state's attorney and so on. But this is a civil matter.
Kadeen, do you have any advice on that?
So just outside of the example of somebody who's raped, they would fall under the protection of qualified immunity under Illinois law. So it would apply to prison guards. They're a different union than FOP, but they're a public official who would have that immunity protection.
And the only way that would not stand is if a judge, whatever the scenario as described here, turns out if the family or someone filed a lawsuit in the civil matter. That's what you're saying, Tarver?
Yeah, and then there would have to be a case that had close enough facts where they could make the argument that qualified immunity doesn't apply. If it were the first case of that kind, then there's a potential that they would find that qualified immunity still applies. And it would be civil, not criminal.
Okay.
Right. And just understand as well, we don't know how many cases are not being brought that will be viable cases because people know that standard is there. It's very difficult, if not impossible, to meet. So that the cases that will have the precedence may not even get to court in order for a judge to rule on them because this doctrine is so impenetrable.
And just add one more layer to that, you may have somebody who is responsible for 30 cases because they've never been held accountable. So it may not be 30 people, but one person who, if you were to be able to play it out and find that this person acted in ways that resulted in constitutional violations, that's something that all entities should want to know. If I were a police chief, I'd want to know if I had that officer in my force. If I were a municipality and I had to do payouts for those cases, I would want to know as well.
Are there other questions? We have one in the back.
I thought I understood, Alderman Evans, that you said that the City of Urbana's labor attorney advised that it would be possible for the legislature to change state law, which allowed for CBAs to supersede state law, that they could change that aspect.
Yeah. He pointed to section 14H to do that.
And that seems to me to be an immediate piece to mobilize around, because if that gets changed, then that opens up all kinds of space for challenging at the local level. And that seems to be the only avenue to do it now, because we avoid that, what do you call it, the interest arbitrator. Yeah, as in the interest of the police.
Yeah.
So did you all hear what Dr. Chajua said? Joy, can you talk a little bit about, we've been working on this very issue, trying to address the section that's preventing us from really dealing with localized collective bargaining. So he's suggesting if we, and that is a really big, tall order, at the General Assembly, say we strike the whole line. Let's just strike the whole line out and say your CBA cannot supersede state law. Is that what your organization or coalition is trying to do? We can't hear you now.
Hello, can you guys hear me? Yes. So yes, if we take, so that section that the Act takes precedent clauses in Section 15 of the Illinois Public Labor Relations Act. And if we take that sentence out, then laws that we get passed in the General Assembly, similar to the Safety Act, will actually be able to substantiate and actually have precedence over, it would actually be implemented. So police unions would not be able to negotiate out of, for example, the destruction of police disciplinary records once that line is taken out.
Seems like a simple sentence, something to do, right? Seem that easy? However, we know that we have to educate legislators to understand why it's a value proposition. If they want public safety, true public safety in the communities, we heard a lot about people being concerned and upset about the uprisings in June, right? As a result of continued abuse of the citizenry. So people are upset about that. They don't want damage to property and disruption of traffic and disruption of meetings to happen as a result of an incident. But they also at the same time don't want us to actually change what causes the incidents. In our last few minutes together, in your closing statements, can you all just share what you see as a vision for us, a way forward for us? And I'll just start with Kadeen and then go clockwise around my screen anyway.
So my vision and our organizational commitment is to run this bill until we get an end to qualified immunity in Illinois, partnering with Rep. Tarver, reps like you, Rep. Ammons, and have all the conversations we need to so that people understand what it is and this common sense bill ends up being law. And also, if folks who are in the room or listening are interested in being involved in a broad coalition doing this work, please feel free to reach out. K Bennett, BENNETT at ACLU-ILL.org, or Rep. Ammons has all of my information and she can share that.
Thank you, Kadeen. Joy, you are next on my screen.
Yeah, so the Workers Center for Racial Justice, we're working on legislation to outlaw police contract abuse that very narrowly limits police officer contracts from including impunity provisions against investigations and discipline of police abuse. As mentioned earlier, we're also working on with the countdown to passing this legislation in light of the new Constitution Amendment that, if passed in 2022, will broadly prohibit the passage of any new language that will shield police officers accountable. And so we're working towards that, and getting this passed is our priority. And if anybody is interested in joining these efforts, feel free to reach out to the Workers Center for Racial Justice. We're on Facebook, Instagram, and also Twitter as well.
Thank you. And Representative Tarver, you are our closer.
Sure. So,
oh, actually, Chris Evans is going to close. My bad.
Okay, no problem. Perfect. He's a better closer than I am, sure. Rep. Emmons has all of my information, so anyone who wants to join in this fight and help support our efforts, I'm happy to do so. My commitment is to continue to push this bill, to work with my colleagues until we end qualified immunity in Illinois. I think it's bad law. I think it's judicially created bad law, and it creates an insurmountable hurdle for individuals who have their constitutional rights violated to have any opportunity to get in front of a jury, a genuine trier of fact, and let them decide whether or not those rights have been violated, and if so, if they should be entitled to any level of compensation. So that's my commitment, not just with this bill, but with other common sense bills that allow everyone to participate in the state in the same way that other individuals have since its inception. Thank you.
Thank you. And I'm going to pass it to what we call him Lucky Lefty, Alderman Chris Evans.
Well, thank you all for your hard work and for participating today. Like I said on council floor, and I think you all agree, transparency leading to accountability improves integrity and provides legitimacy. And I would think the police would want that right now in all their bad press. Even so, locally, I'm going to continue to work with our state legislator, Carol Ammons, in trying to change what laws need to be changed. and then work with Ubuntu, doing this door-to-door grassroots work and trying to, get these things understood. So thank you.
And I truly appreciate Representative Tarver, Kadeem Bennett, and Joy Immobile, right? Didn't I say that right, Joy?
Yep, you got it.
I got it. And just take the H out, Immobile. Okay. We just really appreciate your hard work. We know it's not easy. This is not an easy path to challenge systemic racism in any institution, let alone challenging systemic racism in policing, because it has been acceptable in the United States to abuse Black people, Black bodies. That is part of its inception, and it is part of its fabric. We have to unravel the fabric that allows for the abuse of citizens, regardless to race, creed, or color. And we are intent on doing that. So whether it takes us 1 year, 2 years, 10 years, it doesn't matter. We will stay in this fight, and we hope that those who are watching will join us for the fight, because it is not something that one of us or the 4 of us or the 5 of us could do alone. We need everyone to help us with this issue. As important as clean air, clean water is, we should also have the right to walk freely in the United States without being harassed, abused, or beaten, even if we have committed any kind of crime according to the books. We're supposed to have our day in court without being harmed or abused by the system itself. And so we will continue on this fight. This will not be the last panel Ubuntu sponsors on this topic, and we do hope that other members of our legislative body will host these same conversations in their districts as well, because the people deserve at least that. So thank you all so much for your participation today. Thank you to those who are in the audience here in Urbana that came and sat with us for this afternoon, to my staff that helped us figure this out, to Pastor Thomas and his son who's trying to run this audio, man, to Ubuntu who's trying to organize. Thank you all so much for your commitment. We don't do this because we get paid a lot of money. So be blessed. God bless you all. And until next time, enjoy the rest of your weekend.